Like he's high as fucking going.
Yeah, it's a good time to Okay, good afternoon, everybody. Can you hear me?
Afternoon, yes.
Okay. Just a minute. Let me get my computer set up. So let's see. We have a court reporter.
Yes, Your Honor.
Okay. All right.
Hi.
So, here we go. Just a second. I would ask for the benefit of the court reporter that those of us who speak, just make sure she knows who we are when we speak. And let's see, it's about 2:04 and today is the 19th. And we have present, let's see if I can remember everybody, Mr. Gallagher for the plaintiff.
Afternoon.
Mr. Abel for the defendant.
Your Honor.
Mr. Dodson for the plaintiff. Mr. Weisenhunt, plaintiff. Ms. Patelis, plaintiff.
Yes, Your Honor.
Mr. Bean, defendant.
Yes, Your Honor.
Ms. Barnett, defendant.
Plaintiff, Your Honor.
Sorry, plaintiff. Ms. Paskowitz, defendant. No, plaintiff.
Yes, plaintiff.
Okay, so defense counsel, primarily Mr. Abel, Mr. Bean, everyone else, plaintiff, and Mr. Sheridan. Too.
Yes,
So,
plaintiff, Your Honor. Thank you.
okay. So let me just to let you know, I've read your memos. I've read the motion and the memo that went with it. I've read the plaintiff's memo. I've read each several times. I've read every case you've cited. A lot of the cases you cited I was aware of anyway. I've gathered so much material that if I need to refer to something, it may take me a few minutes. So we're here on the defendants, Governor Corcoran, Commissioner of DOE, Florida Board of Education. So who will be addressing the defendant's motion?
This is Mike Abel, Your Honor. I'll be taking lead on argument for the defendants on our motion this afternoon.
All right, Mr. Abel, feel free. I mean, I think we're set for about an hour, but if you all feel like you need more time, just let me know. Just to let you know, let me repeat, I have read everything. And not just your motions, I mean everything. I've read the complaint multiple times. I've read the attachments to the complaint. I've read the Constitution. I've read the statutes. I've read innumerable cases. So I just assumed everybody sort of get to their best points. Okay, Mr. Abel.
Your Honor, may it please the court, Mike Abel, along with Daniel Bean, Jacqueline Van Landingham, and Jared Burns, on behalf of defendants, Governor DeSantis, Commissioner Corcoran, the Florida Department of Education, the Florida Board of Education. We're here on our motion to dismiss. And thank you, Your Honor, for your comments regarding having read all of the materials. From that, the court is aware that the defendants asserted that plaintiff's complaint raises no justiciable issues. We assert plaintiffs lack standing. We claim that their claims present political questions beyond the purview of the judiciary. We contend that the remedies sought implicate the separation of powers. And Your Honor, these are threshold issues, as I indicated in our status conference. These are threshold issues that we believe the court must resolve.
Aren't lack of justiciable issue and political question one and the same?
Yes.
Okay.
Yes, and I think we've argued, I think we've briefed that as interchangeably, and I think I've argued that.
Okay, I understand.
Your Honor, to your Honor's point, I'm not going to rehash our arguments in the brief. For our principal argument then, Judge Cooper, I'd like to be able to respond to plaintiff's memorandum in opposition and show the court that nothing presented in that response should change the outcome. And in many respects, Your Honor, plaintiff's brief reinforces that dismissal with prejudice is warranted. Before I respond to their brief, Judge, overlaying all of this, I think two key issues bear repeating. The plaintiffs seek to enjoin enforcement of an executive order of the governor that merely directed state agencies to take some future action within their legal means to achieve a policy goal. The executive order, and the court indicated that the Honor had read the exhibits of the complaint. The executive order itself, which is the subject of 5 of the 6 counts, does not itself impose any state action against the plaintiffs. And the actions that have been contemplated under that executive order have already been accomplished. Second, Your Honor, and I think maybe more importantly, in Florida Education Association, the case cited extensively in our brief, which I'm sure the court is very familiar with it at this point. We believe
The DeSantis versus FEA.
Yes, Your Honor.
I read that case about 5 times.
Right. Yes, and that's same here.
Yeah, and I'm familiar with that case anyway. It came out of the Second Circuit, so I'm familiar with cases coming out of our circuit.
Of course. Well, Judge, it's our position that this case is likely the most analogous case for this court to consider because it involved nearly an identical challenge, and that's whether a state level education policy violated Article 9, Section 1A by failing to provide a safe and secure schools.
So, Mr. Abel, does it have to do with similar facts?
Well, I mean, admittedly, Judge, that case addressed requiring schools to hold in-person classes, and the case before the court.
No, they didn't require that. As the First District pointed out, that executive order or that rule didn't require the schools to do anything. The district court pointed that out 2 or 3 times. It was a rule passed last summer, or I don't recall if it was a rule or an order, but it was an action taken.
Right.
In which normally, I'm going to give an example. These figures are not correct. They're used for example. But the state provides school districts compensation for students. The more students, the more state revenue the district gets. They provide a certain amount, let's just say hypothetically $100. Let's say $100 per day for students who are in brick and mortar schools. They provide less than that for students who are distance schooling, who are not in brick and mortar schools, let's say $60 a day. At that time, the state realized, I'm drawing from what the First District has said. These aren't my opinions, they're what I read from the First District. Is that the state realized that a vast number of people are not going to go to brick and mortar schools, and we're going to school from a distance. They realized that if the same rules were applied, the lower compensations for distance, that the school boards were going to take a pretty substantial financial hit. So they proposed to the school boards this: we will, for this year, increase the distance school reimbursement to be the same as the in-school. So everybody would get $100 per student. That will obviate the financial loss you, the district, are going to take. However, for you to be able to receive this waiver of the rule, you have to have brick and mortar schools open, presumably for people who don't desire to educate their children at home because they don't think that was the best for their children, or they don't have sufficient child care, or their jobs don't permit them to have children at home. or for other reasons. So the school board did not say you have to do this. They didn't say if you don't do it, we're going to punish you. And so the first district said it made a point that that was not a requirement to the school boards. The first district discussed a number of rules involving political cases, separation of power. They pointed out that political cases are really, I would call it separation of power by a different name, that they're subsumed into separation of power cases. They talked about the standard of whether it was arbitrary and capricious, I think, and several other issues. So that, as I understand, is the case there. The case here appears to be, from the complaint and from the memos, is that the governor decided that he was opposed to face mask mandates with no opt-out provisions. The executive order was written and that was then, there was a rule passed, Department of Health, an emergency rule, and the executive order tracked the Parents' Bill of Rights, which is, I'm sure everyone there knows better than me, is a statute that was passed in the last session of the legislature, went into effect, I think, July 1. So it seems to me that there are distinguishing facts between the two cases. Now, that doesn't mean that the law's any different. That doesn't mean that the result's any different. But they are two different cases, aren't they?
Yes, of course. I thought the court's summary is exactly as it was framed in the first DCA. I thought the court's brief summary of the initiation of the order, the reference to the Parents' Bill of Rights, that's correct. And I would agree that they're on a different factual basis. But I would respectfully submit, Judge, and we laid this out in our brief, and I'll continue to argue today, that those factual differences should probably have no impact on whether a policy provides for safe and secure schools amid a pandemic is non-justiciable. And I think that's so overarching, first of all.
What is the policy that the governor or the defendants are expounding in this case? What policy are they saying is subject to political issue, separation of powers consideration?
Yeah, it's the preparation and implementation of the governor's executive order, which reflects a policy that would allow the Department of Health to direct the Department of Health to implement rules which would protect safety in the schools while protecting parental rights, as it's spelled out in Governor DeSantis's order. And then the Department of Health issued a specific emergency rule that attempted to protect parent rights and then lay out specific regulations with respect to safety in the schools.
Is the governor's order and the Department of Health rule, which was passed as a result of what appears to be the governor's directive, is the purpose of those to carry out this new law, the Parents' Bill of Rights law, as it relates to face masking in schools?
There's certainly, the governor certainly, in implementing that executive order, had the Parental Bill of Rights in mind. And this would be, the Parental Bill of Rights covers far more than just medical or health issues. But this is a broader, this would be subsumed under that policy and would be reflective of the policy articulated in the Parents' Bill of Rights.
Okay, so you said did you say the executive order doesn't do anything?
As with respect to, it doesn't do any state action with respect to these plaintiffs, and that's the underpinning of our standing.
Does it say to the school districts where the plaintiffs have children that you can't pass a mask, let me try to come up with a shorter phrase, a mask mandate, no opt-out provision. Doesn't it say that?
I don't believe it does, Your Honor. I believe it's
That?
I believe it directs, and it specifically directs the Florida Department of Health and the Florida Department of Education working together to immediately execute rules that don't violate Floridians' constitutional freedoms, do not violate parents' rights under the Florida law to make healthcare decisions for their minor children, and protect children with disabilities or health conditions who would be harmed by certain protocols. It also states that, to Your Honor's good question from a moment ago, any action taken pursuant to the initial section should at a minimum be in accordance with Florida's Bill of Rights. And that was when I answered the court's question about whether this flowed from or was motivated by the Parents' Bill of Rights. The governor put that specifically in his order. And then he directs the Florida Commissioner of Education to pursue all legal means available to ensure school districts adhere to Florida law, and continues from there. And so when I said I hope I didn't say it didn't do anything. It does. It certainly is
That
not.
may just be my Polk County phrase. That's what we would say in Polk County, but you probably said something more sophisticated than that.
I don't know if it was more sophisticated. I doubt it was more sophisticated, but it was the key point was that it did not direct any state action to these individual plaintiffs. And that was, as the court saw in our briefing, is the underpinning of our standing argument.
So let me read you something from the DOH rule that was passed as a result of this order, as I understand the complaint and the exhibits and the arguments. On the second page of it, it's where it says the full text of the emergency rule is, and it's 64 DER 21-12 1 D, and I'm quoting. Students may wear masks or facial coverings as a mitigation measure. However, the school must allow for a parent or legal guardian of the student to opt out the student from wearing a face covering or mask. So I'm trying to frame the issues in my mind. This is not indicated what one thing or the other. I'm just trying to make sure I understand the issues from the party standpoint. But it seems like that's ordering the school districts. It's telling the school districts you can pass a mask mandate, but you must allow an opt-out. Isn't that what that says?
I think that's a reasonable interpretation. And I also understand that that is the policy that virtually every school district in Florida is following, with the exception of, I believe, two. But
Alachua and Broward? Correct.
And I believe the court
is Alachua and Broward.
Oh, thank you.
Okay. So there is actually well, tell me if I'm right or wrong. Does the executive order in the regulation then tell school districts you can institute a mask mandate, but you cannot institute a mask mandate that doesn't have an opt-out provision?
That would be I believe that would be a fair interpretation of the subsection D that Your Honor quoted. Okay,
so, and as I understand, again, I'm doing this from memory, so excuse me if I get the numbers right, but this, I'm conflating matters in my head, so I'll strike that and go forward. So, as I understand, that's the only rule we have, is this one from the Department of Health. Is that correct? Or is there another rule?
The complaint, the operative complaint invokes the executive order, and it refers to this rule.
Okay. I looked for Department of Education. I'm not sure I found one there. I found this other one, Department of Health rule. So now when you say the executive order says you must comply with the law of Florida, and again, that's my own paraphrase, not exactly what you said. I think you said that one of the things the executive order does, and it's attached, as I recall, to the complaint, and it says, hold on, I'll find it. It says, Mr. Abel, I'm not a sophisticated lawyer, so I didn't draft a lot of documents that were full of whereases when I was a lawyer. So as I understand, the whereases are basically a way of saying, this is why I'm passing this order or issuing this executive order. Is that the purpose for that?
I would agree that the preamble is to provide context and
Context for the order?
Correct.
Okay. So the order itself is the part that says, now therefore I, Ron DeSantis, order the following things. That's the order, right?
Correct, Judge. I believe that's correct. Yes.
Okay. So that's like section 1 through 5. Section 1 says DOH and DOE should pass rules to make sure Florida's constitutional freedoms aren't violated. Why is it that we need a rule for that? Isn't that already the law?
Yeah, look, it's a good observation. I believe that this was to reinforce the governor's very strong view that when these rules were implemented pursuant to his direction, I equated constitutional freedoms with the Parental Bill of Rights. I know the Parental Bill of Rights is part of the statute, but I also I believe that I believe the intent behind referring to constitutional freedoms is a broader notion of parental rights that was eventually manifested in the Parental Bill of Rights by the legislature. But to Your Honor's specific question, that's what I believe the intent behind that was.
I suspect you're probably correct on that, but as I understand the Parents' Bill of Rights, that's intended to codify into a statute the law of Florida as it relates to parental rights on areas that were mentioned in the law, education policy, health policy, which are two of the things mentioned, correct?
Among others, that's correct, Judge.
Okay. So, all right, we go from A, then we go to B. Don't violate parents' rights in the Florida law to make healthcare decisions for the children. That's Parental Bill of Rights too, isn't it?
I believe that that's what is intended by that comment, correct?
So like my dad used to say, if one's good, two's better.
Yes, I think that's right.
Okay, I understand. I was a lawyer before I got this job. I understand the idea of making sure that your point's made clear in your documents. So we go to C, protect children with disabilities. I think that's explanatory. In section 2, it says, as a minimum, comply with the Bill of Rights. So that seems to also be saying, we've got the Parents' Bill of Rights. We want this complied with, right?
I believe that very much reflects the governor's intent. Correct.
Okay. So the Parents' Bill of Rights was passed by the legislature, right?
Correct.
And so it's the legislature that decides what's to put in that law, right?
Clearly.
I don't decide, right?
Our elected representatives.
The governor doesn't decide what to put in that law. That's the legislature, right?
Correct.
Okay. So 3 is pretty clear. 2. 3 is Commissioner of Education shall pursue all means available to ensure schools adhere to Florida law. So I think it means what that says. He wants the Commissioner of Education to make sure the law of Florida is followed. Right? Or am I missing something?
Those are clearly what the governor is intending by those words in section 3.
Is he referring there to the Parents' Bill of Rights again?
I believe that the governor in that phrase is referring to, it doesn't cite to them, it doesn't reference them, but I believe there would be other laws available that for enforcement beyond the Parent Bill of Rights that would be available to the Secretary of Education or to the Surgeon General in terms of ensuring that the school districts adhere to Florida law. So I don't know exactly, Judge, but I don't know that it's necessarily just limited to the Parent Bill of Rights.
Okay, I understand. Now, I have to be an expert on everything. So one of my law partners used to say my knowledge is a mile wide and an inch deep. So I've looked and I've been unable to find anything other than the Parents' Bill of Rights, and of course this order here that deals with face mask issues. Is there anything else? I just want to make sure that I know that if I need to look at something else, I'll look at it. As far as you know, Mr. Abel.
Right. As far as I know, I don't, but we're really just responding to the allegations and claims that have been asserted by the plaintiffs. I'm not trying to duck the court's question. I'm not aware of anything else.
I understand. I appreciate that. So that's 3. And I do know under that section of that chapter of law that the Parents' Bill of Rights is under 1014. There's a whole string of things. If you look at the top of that, it starts at like 1001 and then goes through 10, some more 10s.
Right.
And it says education at the top. So these are all different things that relate to education. I know it's not exclusive, but it seems to be limited to education, right? If you look at the statutes.
Yes, I've got, like the court, I've got a number of things around as well, and I'm trying to pull things as Your Honor was referring to them. And so I may not be looking at exactly what the court was referring to. And so I
totally understand.
Okay.
My question is, if you look at the enforcement part of the Bill of Rights, I didn't really see much in the section 1014.101 through 6. But what I saw later on down in that whole series of statutes at the bottom in the statute book appeared to be various ways to enforce everything that was included in that body of statutes referring to education. So I know that's not the clearest question in the world, but my question is that where the enforcement is for the Parents' Bill of Rights? Hold on a second and I'll let me see if I can get to that section. Let me pull my statutes up here. I go down to, it's called the Education Code. Starts with chapter 1000 and it goes through chapter 1013, and 14's at the bottom of that. And it seems like Chapter 1008 has something called assessment and accountability. Is that where the taking money away from school board comes from?
Correct, Your Honor.
Okay, that 1008?
Correct.
All
and when
right.
I mentioned into the courts, I was trying to find this, Your Honor, and I didn't mean to interrupt, Judge.
No, that's okay.
To the court's question from earlier about authority beyond the Parent Bill of Rights, the court citing the 1008.32, when the executive order referred to the Commissioner of Education pursuing all legal means available to ensure school districts adhere to Florida law, I did not believe it was strictly limited to the Parent Bill of Rights, and I believe the court has pulled and identified a source of enforcement under 1008.32.
Okay, so
I'm sorry, Judge. In fact, that's the exact, if I'm right. No, go ahead. I'm sorry, Your Honor.
all right, so I think I'm just trying to understand here. In a minute, I want you to finish your argument, but part of this is to help me understand some of these more technical issues from both sides. So Section 4 of the executive order, I don't know how many executive orders I've read, but it's not something I do as a hobby. So I don't know that I've ever seen this provision. This doesn't prohibit the legislature from meeting and passing some more laws. Is that a common thing in executive orders, or is that something unique to this one?
I don't know specifically, Your Honor. I will say that what this reflects is that the governor recognizes that the legislature are the representatives of the people, and that if the legislature was to meet to explore legislation to further protect the fundamental rights of students, that they would perfectly be free to do that. And this expressly acknowledges that.
Okay, I understand. So I had another question from your memo. Sorry, I'm jumping around a little bit. But,
please, Your Honor, please.
And then it says, let me see if I can find it. I made a note here and I'll find it. It says, I think I understand your position from your memo on page 3 that it's the governor's contention that his authority to have the agencies adopt rules is under Article 4, Section 1A of the Constitution. Am I reading your memo right on that?
You are, Your Honor.
Okay. And that's that thing that says he's got supreme executive authority and that he must enforce the laws, something like that?
Exactly correct, Judge.
Okay. So, and then I'm going down on something else on page 5 of your memo. It argues that only the local school boards will have standing to argue that the executive order violates Article 9, Section 4. That's the provision that's been relied upon by the plaintiffs, stating that it's school boards the local school boards are supposed to run the schools. You indicate in your memo that the school board would only have standing, not the plaintiffs. Is that right?
Well, we believe the plaintiffs absolutely do not have standing. Whether the school boards do, they probably do, but they're not in this case. You
are aware of the First District case, School Board of Collier County versus FEA 279 Southern 3rd 281.
I am.
It's cited later in your memo.
I am, Your Honor.
You are aware that was a case I handled, aren't you?
I may not have been, to be perfectly candid with the court.
You are aware that I took the position you just espoused about the school boards having standing to challenge a statute?
I'm pulling the case, Your Honor.
So you won't have to pull it. I was reversed on that point. And and I'm not arguing with it because the First District tells me what the law is. I don't do it the other way around. But they found that a school board doesn't have standing to challenge a law because a public official, or in this case, a school board, can't challenge the constitutionality of a statute that has statutory duties that govern the action of that state employee or state agency. There's a name for it, which I've forgotten, but it's a principle recognized. I've been reversed at least once on that, and that was one of the cases that's what I remember the cases I get reversed on, and for good reason, because I want to learn and do it right the next time. So I have to say, unless you figured something out that I haven't, I want to know why you think the school boards have authority to challenge this order.
Yeah, Judge, if that was the implication of our brief, then I didn't communicate that accurately. If the school boards don't have standing, then these plaintiffs absolutely are not going to have standing.
So does anyone have standing?
Not in this case.
So the plaintiffs say, this is their position. It's not my position. It's the plaintiff's position, if I can say it. They say, as I read their complaint in part, this is different from a year ago. A year ago, we had, I don't know what they call it, the type A COVID, and it was generally thought to be not very transmissible among children. And then say now it's different because of the Delta variant is transmissible. And I'm not going to say the word highly because I would wait to hear testimony whether it is, but I think they allege it's more transmissible between children than the other one, which I'm reading in between the lines, and I don't want to state for them what they're going to say, but I think they're saying that's one of the things that makes it different now than from what it was a year ago. But I am wondering, what is your response to that?
Two things. Number one, the legislature was aware of the new strains of COVID at the time of passing the Parents' Bill of Rights. The governor was aware of this when the executive order was entered. The Surgeon General was aware of this when the Department of Health rule was implemented. And so the risk factors, particularly when it comes to the governor's executive order and when it comes to the Department of Health's regulation, have been assessed, and determinations have been made that balance, in the view of the executive branch, safety and health and providing the best educational environment. Those determinations have been made. Now, so that's part one. Part two, as it relates to standing, as a legal matter, Your Honor, I don't believe that the increased risk factors of a strain of COVID change long settled standing law in Florida regarding standing and whether there is imminent harm, and whether it's last year's COVID or this year's COVID. We don't believe, defendants don't believe that changes or alters the assessment of damage or impact as the first prong of the standing analysis.
So if, by the way, I'm not ignoring the first district standing analysis in the DeSantis FEA case because they went through it in a lot of detail. But what I want to see if I can understand, is it the position of the defendants that saying that the schools can't pass a mask, no opt-out mandate, they cannot do that under any circumstance? I think that's what I'm hearing. Is that correct? They just can't do it.
Well, that would be inconsistent with the Department of Health rule that was followed by the government, that followed the governor's executive order. Okay,
so the plaintiffs are saying because of these new conditions on the ground, that's not reasonable, and they might use more technical terms. They might say that's arbitrary or there's no reasonable factual basis for that. So I'm not saying they're right or they're wrong. I'm not saying you're right or wrong, but under that scenario where children are catching COVID in the schools now, I think I can take judicial notice that is occurring. As I understand the defendant's position, there is no one who can challenge whether that policy is constitutional or not.
Just to specifically answer the court's question, I don't know that we've analyzed whether there is a plaintiff out there of some capacity that could challenge this. What we do know is that these plaintiffs, that parents lack standing for the reasons articulated in our brief. The court, and I appreciate this, Your Honor, we had written that perhaps the school boards have standing. Your Honor was adjudicated a case that held otherwise, and so I appreciated that. But I don't know that we've thought about who would have standing. Okay,
would a child in second grade who caught COVID and is in the hospital, would he or she have standing?
You know, I don't know, because I don't believe so, Your Honor, because of the other standing factors beyond injury. Okay, there's causation and there's redressability, and so
right.
Even if there is a harm that's occurred, there still needs to be causation. There still needs to be redressability. And when it comes to this executive order, there's no link or connection between the order itself and an unfortunately a child who may have become infected with COVID, either at school or in some other place.
All right, thanks. So let me switch a little bit, Mr. Abel. This is for my education. Let's get away from the intermix between local school districts and the legislature has always been interesting to me, because it's never been clear to me where the dividing line is between the school board's ability to control and the legislature passing laws. For example, the plaintiffs say the school board has a right to control, but I know in one of the statutes I saw that I think was quoted as a basis for this order is 1002.33 or something like that. 1003.223. And this is what leads up to my question. That statute mandates that requires school children to get vaccinated for like 6 or 7 different things: polio, measles, mumps, a couple other things. So the state can do that, even though the Parents' Bill of Rights says the parents have the rights to make health decisions for kids.
I believe that I can pull it, but I believe it provides unless otherwise provided by law. And
okay. So, all right. Who makes, I don't know if we can settle today where that line is between local school boards and the state, but as far as the state's concerned, who in the state is in charge of legislating or governing the local school system? Is it the legislature or is it the governor? Who has that primary job that passes the laws? Now, we can talk about regulations in a minute, but who passes the statutes like 100322?
Right. Well, for example, 1001.02, which establishes the general powers of the State Board of Education. That's passed by the Florida legislature.
Right.
1003.22, which Your Honor just cited, which, by the way, is the statute authorizing the emergency rule that's at issue before the court, issued by the Department of Health. That's also passed by the legislature.
That's the statute. I thought 12054 authorized emergency rule procedure.
Yes, that authorizes the emergency rule, but the specific authorization, the specific rulemaking authority for the notice of emergency rule 64 DER 2112 is 1003.22.
Oh, I thought it was the executive order. It's not the executive order?
It's not the executive order. It's the statute 1003.22.
So who's the head of the Department of Education now? Is that Mr. Corcoran?
Commissioner Corcoran, correct, Your Honor.
Okay. So from the defendant's standpoint, to the extent the state of Florida sets policy for schools, the legislature passes the bills. And then if there are rules and regulations passed, that's done by the Department of Education under a mandate from the legislature to pass rules to enforce the statute. Is that the way it works?
In part, but also Commissioner Corcoran is an executive officer under the direct supervision of the governor.
Right. So what does that mean? I'm not sure I understand.
Well, that's another, if it would authorize the commissioner to issue rules pursuant to executive orders.
So the governor can tell Commissioner Corcoran to issue a rule?
Similar to the executive order that asked the Department of Education to work with the Department of Health to issue a rule pursuant to the executive order that's before the court.
Is there a statute that authorizes the governor to direct the commissioner to issue a rule? Or where does that power come from? Is it from the legislature?
Chapter 20, and I will cite to the court the exact.
Chapter 20. That's the chapter that sets up DOH as a department in DOE, right?
Actually, Your Honor, section Florida statute 20.02, subsection 3.
20.023. Administration of any executive branch department placed under the direct supervision of an officer or board pointing at or serving at the pleasure of the governor shall remain at all times under the constitutional executive authority of the governor, et cetera, et cetera. When was that passed?
This was passed following the decision of Wiley against Scott, which the plaintiffs cite in their brief.
So that's the Supreme Court case that said the governor can't suggest regulations.
Correct. And then
this was passed to avoid that.
Well, it wasn't passed. I mean, yes, but it's the legislature specifically abrogated the majority holding in Wiley against Scott. And the language that the court just read from 20.023 was the language that the legislature added following its decision to abrogate Wiley against Scott.
Has there been, I can check this later, but has there been any case interpretation of that statute that you know of?
Not that we know of, Your Honor. We have not found any.
Okay, so that answers that question. So then going on, I know, Mr. Gallagher, I know I'm going to give you equal time, but I'm just, it may be I don't have to ask you as many questions unless you differ on some of these answers Mr. Abel's been giving. But and I'll try to stop it with this, Mr. Abel, and if you have further, I'll be glad to hear your argument. But you said one thing that I wanted to ask you. I'm not sure what was meant there. Let me see if I can find it. I have a note on here. I think it was on page 17 of your memo. You say, and I'm quoting from your memo down at the last paragraph, quote, the executive order either precludes, okay, it says the plaintiffs have based their case on a fundamentally flawed premise. And you're saying the plaintiffs are wrong when they say the executive order precludes school boards from enacting mandatory masks or bans school boards from enacting mandatory masking. So when they say, I think what I'm hearing from the plaintiffs is they're saying, you have stopped us from doing this. We don't think that's constitutional. Are you saying the order hasn't stopped them from doing that?
I'm saying that that for the plaintiffs to claim that the order bans school boards from doing anything, whether it comes to enacting mandatory masking or banning school boards from enacting mandatory masking. No, respectfully, we disagree. The executive order does not on its face do that. There's no state action to school boards on the face of this executive order. There's no.
Okay, so then is it the DOH order that does that? Or does any order not do? Is there any order that does that?
The DOH emergency rule as it is what the court cited earlier in terms of what the operative emergency rule now is, and the court cited to subsection D, students may wear masks or facial coverings as a mitigation measure. However, the school must allow for a parent or legal guardian of the student to opt out the student from wearing a face covering or mask. That's the subject of the rule.
So you are, I don't think, the reason I'm asking you this question is when I first read it, I was wondering what I had been spending the last week reading for when you said it didn't require the schools to do anything. I think what I'm hearing you say, the executive order doesn't require it, but the Department of Health rule does not require it, but prohibit mandatory masking, no opt-out.
Well, yes, and to the point, and judges, again, we filed a motion to the complaint as it was filed. 5 of the counts are directed specifically toward the executive order. It asked this court to find the executive order unconstitutional. It asked this court to find that the executive order was arbitrary and capricious. It asked this court to enjoin enforcement of the executive order. There is one count that claims that the rule, the emergency rule from the Department of Health, violates the Constitution, and it is the same argument that schools should be safe and secure, and that this rule would cause them to be unconstitutional because it is not safe and secure. And so we focused a majority of our briefing and our argument to the way that the case was framed, and that was a frontal attack on the constitutionality of the executive order in 5 of the 6 counts.
Okay, so there's still something for me to do in this case then, because at least the Department of Health order does, as I read it, seems to say you can't do this thing that Alachua County and Broward County have done.
I'm sorry, but Judge, if you were asking me,
That's okay.
I don't know if I followed exactly.
Let me, when I say you can't do this thing is mandatory masking, no opt-out, which I have to be honest with you, I'm reading this from your memos and from the news media, not from the pleadings, but I don't think there's any dispute that Alachua County and Broward County are the 2 counties right now that are doing that, unless things have changed. But are you arguing that the Department of Health order does say to the school boards, you can't do what Alachua County and Broward County are doing? In other words, enact a mandatory mask requirement, no opt-out.
I don't believe that that's the full import. I don't believe that's a full, respectfully, Judge, I don't know that that's a full and accurate reading of the executive order. There are.
Tell me what it does say.
Well, there's other provisions that would then allow the department to assess what penalties could occur for noncompliance, and so the school boards can implement mask mandates, and there may be consequences. Okay, so I don't necessarily agree that it bans it, and that's the end of it. Okay.
Well, isn't that like saying, we're not telling you can't drive drunk, but if you do drive drunk, we're going to put you in jail?
I don't know that that's. I don't know that that's exactly. I don't know if that's the best analogy, but it's not. And by the way, it was the same thing in the Florida Education Association case. There were incentives for compliance, which were found to be perfectly reasonable. And so I don't know that
there was no penalty for noncompliance there. the noncompliance in that case was, we will enforce the Florida statutes and the rules as have always been enforced. There was no penalty for noncompliance in the DeSantis FEA case.
There were incentives for opening up schools live in order to obtain funding due to the decrease in school enrollment, and,
Okay.
and not be penalized because of students who chose to learn online. And I guess, Your Honor, I didn't mean to cut you off, Your Honor.
No, that's fine.
Okay. To Your Honor's last point that there's still something to do here. A majority of our brief focuses on political question. It focuses on separation of powers, and I would, to the court's point. I mean, the plaintiffs, absent this court dismissing the case, these plaintiffs, want to have a trial next week. Okay, and so if there's a trial, if the claims go, if a claim goes forward, first of all, we submit that all the claims are due to be dismissed, and they're due to be dismissed with prejudice. And the court, and there's sufficient support for that as articulated in our brief. And I do have some additional argument to make, although I know we've used up time for the plaintiff. But next week, and the court indicated that you would set aside 3 days. I mean, the court will hear from experts, and the court will hear widely differing views on masking in schools, the efficacy of masks in the transmission of disease, the efficacy of masks involving the social, emotional, and educational impacts of children where there's mandatory masking. There'll be widely differing expert opinions on that. The court will hear from parents who offer widely differing views on masking in schools, and their sense of their rights and safety issues. The court will hear from policymakers. The court will hear possibly from students in the school systems. And then what happens? What happens at that point, Judge Cooper? I would submit that the court would be walking squarely into a non-justiciable political question. This is what we've framed in our brief. And the non-justiciable political question would be whether the executive order that you have asked us about, and whether the emergency rule that you've asked us about, implicate safe and secure public schools, and whether there's been a constitutional violation, and specifically Article 9, Section 1A. Now, we talked about it earlier, Judge, and we recognize that the factual underpinning was different. The first DCA did hold just last year that any judicial effort to evaluate the state's compliance with its constitutional and statutory requirements would violate Florida's strict requirement for the separation of powers. That's what the court held. And it also held that the terms safe and secure, as used in Article 9, Section 1A, lack judicially, and this is the key part for the court, lack judicially discoverable or manageable standards. And what the first DCA was saying is, and what it actually wrote, is that the court clearly saw the perils of judicial decision-making in this policy-laden arena. That's exactly what the court said. And so this was the largest subject of our brief. This is exactly why the political question doctrine and separation of powers are jurisdictional bars. They're not affirmative defenses, as the plaintiffs argued. That's not an accurate, that is not an accurate state of the law. This
Really?
Yes.
They sure look like affirmative defenses to me.
Your Honor, and we cited to the court Coalition for Coalition for Adequacy and Fairness in Schools, Florida Supreme Court of Florida 680 Southern 2nd 400.
Yeah, that's the case that Circuit Judge George Reynolds ruled on, and it was affirmed by the DCA and went up to the Supreme Court. I'm familiar with that.
Right, and that was a case dismissed on a motion to dismiss because it raised a political question and would implicate the separation of powers. I mean, that case stands in the same.
I might have the case mixed up with a different one.
This was a 2000, excuse me, Your Honor, this is 680 Southern 2nd 400, and it's from 1996.
Okay, that's a different case than the one I just mentioned.
And it's cited in our brief, and it affirmed a trial court's decision to dismiss a case at the motion to dismiss stage because as the pleading was framed on the complaint, it supported dismissal because it raised a political question and involved the separation of powers.
So, Mr. Abel, how do you decide that the separation of powers applies?
You can look at the remedies that the plaintiffs are seeking and would involve, and this is what the first DCA was talking about in the DeSantis against Florida Education Association when it was talking about the separation of powers. The trial court, in reference to separation of powers, the first DCA wrote that the trial court cannot grant their requested relief, which was an injunction enjoining enforcement of an emergency rule, without wading into the political thicket of education policy, emergency management, public health policy to determine what is necessary for the state to provide a safe and secure public school system. In addition, the first DCA held that the term safe and secure is used in Article 9 lack judicially discoverable or manageable standards and wrote that any judicial effort to evaluate the state's compliance with those constitutional and statutory requirements would violate Florida's strict requirement for the separation of powers. And so when I was noting to the court what a trial would look like next week, what the court would hear, the type of testimony that the court would hear, which by the way is not terribly different than the type of testimony the legislature might take when it's coming up with legislation and hears from citizens and hears from policymakers and hears from experts. That exactly what the first DCA was articulating in last year's case involving Governor DeSantis and this pandemic and safety issues involving the school is that the perils, the court was clearly warning that the intrusion of the judicial branch into this type of decision-making authority in an area heavily involving education policy, health policy, safety policy was would violate the separation of powers and were inherently political questions. And what the case from what the 1996 case, Coalition for Adequacy against Childs, held is that a motion to dismiss that raised political question issues and raised separation of powers on the face of the complaint itself was properly subject to dismissal on a motion to dismiss, was not an affirmative defense. And I would respectfully submit to the court here that as framed by this complaint, by the allegations of this complaint, what these plaintiffs have asserted is indistinguishable from Coalition for Adequacy, 680 Southern 2nd 400. And in terms of the legal work that the court would have to do, in terms of the legal rulings that the court would have to make, are indistinguishable from what the first DCA ruled in the case of the DeSantis Florida Education Association case we've been discussing this afternoon.
Okay, one last question for me, Mr. Abel. Looking at page 33 of your memo, which is towards the end.
Yes, Your Honor.
As I understand, it says neither the executive order nor the rule, that's the DOH rule, require that unvaccinated or non-vaxxed children attend school. It says, quote, rather they seek to ensure that school boards are complying with the Parents' Bill of Rights, leaving the decision of masking children to the children's parents. Does that, like a sentence, summarize what the position of the defendants are as to what the executive order and the rule are seeking to do?
That is an encapsulation of that. there are other, yes, to answer the court's question.
Okay. All right. So let me ask the court reporter, do you need a short break? Does anyone need a break before we go to the plaintiffs?
I would like 5 minutes just to use the restroom.
Okay, let's take 5 or 10 minutes and we'll come back. And Mr. Gallagher, Mr. Abel has very professionally answered a lot of questions on details and procedures, which unless you disagree, I'm probably not going to ask you the same question unless you think you have a different answer to those, or whoever's going to present from your side. I don't know if it's you or not, but we'll come back and hear from plaintiffs. Mr. Abel, thank you for, you were well prepared, and I could tell that you've read a lot of materials over the past few days. So thank you very much. And we'll come back in 5 to 10 minutes. I'm going to leave the Zoom on. I'll just walk out of the office. Whoever, if there's anybody running YouTube, do not turn YouTube off. We're not done. And then we'll come back and hear the plaintiffs.
Very good,
Okay,
Your Honor.
so
Thank you.
I have it about 3:09, and I'll be back about 3:19, something like that. I won't start without anybody, so don't worry about that.
Thank you, Your Honor.
Thank
We'll
you,
take
Your Honor.
a brief break.